Okay, it is 2 o'clock, but as I said, I'll give it another 60 seconds or so, just in case folks are having problems logging on or logging in. In the meantime, I would like to thank everyone who has joined so far. We're always excited to do our trainings and always excited to have folks participate and to share in the fun with us. So we certainly thank everyone for coming and joining us today for this particular training. Just a couple of more minutes, and then we can get started. Okay, all right, so we'll get started. We have a nice group of folks now, so I think that we can go ahead and get started. So good afternoon and welcome to DC FOIA Advisory Opinion Review. I'm Neal. I'm the Chief Counsel at the Office of Open Government, and I'm joined by my colleagues from the OOG, including our Director, Neal Allen. We're also joined by the rest of the Office of Open Government team, including Attorney Advisor Joan Lelma, Attorney Advisor Brandon Lewis, our paralegal specialist, Kimberly Brown, and our IT specialist, Kevin Brown. Our attorney advisor, Anthony J. Skirbo, is actually out of the office today, but I'm sure he would miss this because he is actually our FOIA officer. And so we'll make sure that he gets a recording of all of this. So today we're going to discuss 3 advisory opinions published by the Office of Open Government. Giving you a brief background about each of those matters, the legal arguments at issue, and the director's rationale and the conclusions. Hopefully you'll find these cases and the opinions interesting and enlightening. So before we get to the meat of this presentation, I'd like to start by reminding some and informing others about who we are. So let me move along here. Okay. This is to let you know who we are, what we do, where we came from. And then after that, we'll go into the cases. Also, I want to just a little housekeeping. If during the presentation, if you have any questions, please feel free to put them in the chat and my colleagues will try to answer them, or we can discuss those questions after the presentation is over. So thank you again for joining us. And so let's get started. So most of you are familiar with the Office of Open Government, but for those of you who are not, the Office of Open Government is a component, along with the Office of Government Ethics, under the Board of Ethics and Government Accountability. OOG is overseen by the Director of Open Government, Neal Allen, and it has been in operation since April of 2013. The Office of Open Government interprets and monitors compliance with the Open Meetings Act, which requires all public bodies to provide proper notice of and access to detailed records of their meetings, and the Freedom of Information Act of 1976, which is what we will be discussing today, which concerns the transparency and availability of public records. OOG also provides guidance, including formal advisory opinions to public bodies on compliance with the OMA. OOG also conducts trainings and outreach and can also enforce the OMA on the basis of complaints from the public. As a last resort, we can also can sue public bodies in the Superior Court for injunction, declaratory relief, and for civil fines. For purposes today, obviously, we won't be discussing the OMA. The Office of Open Government also monitors and gives advice on the Freedom of Information Act of 1976. And most of you here, I believe, I think some of you are FOIA officers, so you probably have had a lot of dealings with us, and particularly with Attorney Skirbo, who's not here. So some of this stuff would probably be particularly interesting to you. So a little bit about our agency and our personnel. The Director of Open Government may issue advisory opinions on the implementation regarding DC Freedom of Information Act, and that is the appropriate statutory, the regulation up top. Our public policy is, the public policy of the District of Columbia is that all persons are entitled to full and complete information regarding the affairs of government and the official acts of those who represent them. So to support the district's public policy, the Director of Open Government is authorized to issue advisory opinions on the implementation of DC FOIA pursuant to the relevant section and of the Government Ethics Acts of 2011. So again, as I said, we will have 3 FOIA opinions that I will walk through today. One is a FOIA advice concerning the use of multiple extensions, and this one involves the Executive Office of the Mayor, also known as EOM. The second is a FOIA appeals backlog case, and that's regarding the Mayor's Office of Legal Counsel, which we call the MOC. And then the last one is one that we've gone over before, but I think bears going over again for reasons that I'll explain later. The Deputy Mayor for Planning and Economic Development under the Freedom of Information Act. So all the mayor's offices, and we're not picking on the mayor's office. We just take them as we receive them. So the first case we'd like to examine is a FOIA case regarding FOIA advice regarding the multiple use of extensions. And that is an opinion that was published here at the Office of Open Government, and that is the case number, the matter number. Of course, you can always go on DC Open Government. What is it? OpenDC.government.gov. Keep forgetting our website, but you can go on the Open Government website and you can review all of our published opinions. This is one of them. So at any time, when we go over these opinions, or we teach these classes, or we go over some of these advisory opinions that have been published, you can always go to our website and you can review them yourself. The matter involving this particular case, it addresses the use of multiple extensions by the Executive Office of the Mayor in response to DC FOIA requests by the requester. Thank you, Joan. Joan just our attorney, Joan Loma, just posted our website. So I garbled it up. So she jumped in there to save me. She does that a lot. So I appreciate you, Joan. Thank you. So the request regarding this particular advisory opinion was to evaluate whether the Executive Office of the Mayor's decision to cope with delays involving multiple extension is the correct implementation of the law. In other words, is it legal for them to continue to invoke all of these multiple extensions, as you will see very shortly? The relevant law that's implicated in this is regards FOIA time limits and extension, and that is Section 2-532C1 of the DC Official Code. And that says that except as provided in paragraph 2 of this subsection, a public body, upon request reasonably describing any public record, shall within 15 days, and that excludes obviously the weekends and any public holidays, legal public holidays, of the receipt of any request made either by public record accessible, or notify the person making request of its determination not to make the requested public record or any part thereof accessible and the reasons therefore. Sorry, I'm trying to get my. Also, Other relevant law regarding time limits and extension is Section 2-532D1. And it states that in unusual circumstances, the time limits prescribed in subsection C1 and C2 of this section may be extended by written notice to the person making such a request, setting forth the reasons for extension and the expected date for their termination, and that these extensions should not exceed 10 days, except taking out the weekends and legal public holidays for records requested under subsection C1 of this section, and 15 days, except those holidays and the weekends, for records requested under subsection C2 of this section. Another law implicated in this is section 2-532D2. And it says, for the purpose of this subsection and only to the extent necessary for processing of the particular request, unusual circumstances. It goes on to define exactly what unusual circumstances are. One is the need to search for, collect, and appropriately examine a voluminous amount of separate and distinct records that are demanded in a single request. Very often, that is one of the reasons that unusual circumstances that is cited. Sometimes there are just so many records that have to be examined, have to be reviewed, and so that usually takes time. In that case, this particular revision takes care of that. The need for consultation, which shall be conducted with all practicable speed and with another public body having a substantial interest in the determination of the request, or among two or more components of a public body having substantial subject matter interest therein. In other words, sometimes you just have to talk to another body, you have to talk internally. Often when we're doing investigations, we can't, I mean, these advisory opinions don't just spew out as quickly as we get them. Oftentimes our attorneys or myself have to conduct investigations in order to properly advise the director on the advisory opinion. And so sometimes that takes time. That is the case here. Oftentimes when FOIA requests are made, sometimes the body where the request is made, from whom the request is made, sometimes they do have to confer with other bodies in order to secure the records that are being requested. Another law is Section 2-532E, and that says any failure on the part of a public body to comply with a request under that subsection A within the time frame of subsection C and D shall be deemed a denial of the request, and the person making that request should be deemed to have exhausted their administrative remedies with respect to that request, unless that person chooses to petition the mayor pursuant to section 2-537 to review the deemed denial of the request. So if that determination is not filled within the time frame, then it is deemed a denial, and that person is deemed to have exhausted all the administrative remedies and then can seek a petition or review. So I'd like to give you a little bit of background and the timeline of this particular case. And in this case, it starts in December of 23, and that is when our requester submitted a DC FOIA request to the Executive Office of the Mayor through the district's online FOIA portal, which is FOIA Express at the time, regarding the mayor's travels during a particular time frame. On January 18th, the EOM's FOIA officer sent the requester a notification of a 10-day extension, citing the unusual circumstances that we spoke of earlier, and described the need to consult and the need to search for, collect, and appropriately examine a voluminous number of records demanded by the requester's request. The EOM ensured that a determination or an update on the status of the requester's request would be made by February 1st of that same year. Then on December 31st, which is the day before their promised to have a determination. A second notice of extension indicating that EOM was exercising an additional 10-day extension and setting a new date for a determination to be made by February 21st. So on February 2nd, the requester received an email from EOM, which stated that they had identified the emails and the Teams messages that are responsive to the request, but they had not yet been able to review all of the text messages, the WhatsApp messages, and some of the analogous messages in various apps. EOM then asked the requester, would they be open to narrowing this portion of their request? And on February 5th, the requester responded by email, agreeing to limit the scope of that request, saying that all the staff members mentioned in February 2nd, 2024 email. On February 13th, the requester received an email from EOM asking again if the requester would be opening to limiting the request to just text and WhatsApp messages. And it stated that, further stated that EOM had not received a response from the requester and notified the requester that if they did not respond within 10 business days, ending on February 28th, then that request would be considered closed. So on that same day, the requester immediately responded, and they replied to the February 2nd email, and the requester forwarded a copy of their February 5th, 2024 email, and they also agreed to limit the scope of the request. So I'm sorry, I think someone just said that they don't believe the slides had met up with what I'm saying. So I'm looking at a slide that says background and timeline continued to. Does everyone see the same thing?
No. We see slide 12.
You're seeing slide 12.
Lewis, it just jumped to slide 14 now.
That's strange. Okay, so is that
okay,
that 12?
Now it's back on 12. Yeah, it's back on 12.
Yeah, that was the one I was just talking about, but someone said that that wasn't on 12. Okay. All right. Not sure why that's happening, but I apologize for any technical errors that are going on. Okay, so we'll go ahead and continue. So we're looking at if we're looking at slide 12, the last bullet point says January 13th, 2024. Are we all still on the same page there?
Okay. Yes, Louis. Yes, we're on 12.
Yes.
Wonderful. Thank you very much. So it says January 31st, 2024, a second notice of extension indicating that EOM was exercising an additional 10-day extension and setting a new date of determination for February 24th. So, and I believe, so I think I'd gone over this, so I think that that's where we were running into problems. For some reason, I think it was showing the previous one. So I will, if I'm repeating, then I'm sorry for that, but I wanted for those folks who did not have an opportunity to see this particular slide along with my commentary. So we'll do this slide over again. So on February 2nd of 2024, the requester received an email from EOM, which stated that they had identified emails and Teams messages which are responsive to the request. However, they had not been able to review text messages and WhatsApp messages and other messages from other message apps. And they asked if the requester would be open to narrowing this portion of the request. So on February 5th, the requester responded by email agreeing to limit the scope of the request and indicating that all of the staff members mentioned in the February 2nd, 2024 message. Then on February 13th, the requester received an email from EOM asking again if the requester would be open to limiting the request to text and WhatsApp messages. The emails also stated the EOM had not received a response from the requester and notified the requester that if they did not respond within 10 days, the request would be considered closed. On that same day, the requester responded saying that they had replied to the February 2nd email, and they forwarded a copy to EOM, and they also forwarded an email agreeing to limit the scope of the request. EOM responded on February 14th that the requester's email had gone to their spam folder, and they agreed to move forward with the request right away. So on February 15th, and I know this whole timeline thing can be a little tedious, but it's important because it goes to obviously the director's analysis and conclusions as it relates to this particular case. So on February 15th, the requester received another extension notification, which provided a March 1st, 2024 date of determination. And as you see, they also subsequently received, the requester subsequently received identical extension notifications from EOM on March 1st, March 15th, March 29th, April 17th, and April 30th. Finally, on May 30th, EOM sent requester a letter stating that the documents responsive to the request had been delivered via the FOIA portal, and informed the requester that documents and portions of documents had been withheld pursuant to two FOIA exemptions, Section 2-534A2, which is information of a personal nature, where the public disclosure there would constitute a clearly unwarranted invasion of personal privacy, and 534E, and that is the deliberative process privilege as incorporated under DC Code 2-534A4. The Executive Office of the Mayor also advised the requester of its rights to appeal the letter to the Mayor of the District of Columbia or the Superior Court of the District of Columbia under these particular laws, DC Official Code Section 2-537 and 1 DCMR 412.8. So now we would like to go to the director's analysis of this particular case at this point. So there are several problems. The problem number one that we'll identify is EOM's notification to the requester invoking an extension to a determination did not comport with FOIA's requirements. Specifically, the director cited 1 DCMR section 405.5C. This regulation requires that the agency inform a requester of their right to treat the delay as a denial and of the appeal rights provided by DC FOIA and the FOIA regulations. So in this particular case, EOM failed to include this information in the January 18th, which is the first extension, notice of extension. In this regard, EOM's January 18th, 2024 notice of extension did not comport with FOIA's requirement. The second problem is EOM failed to make a determination to dispatch the requested records within the applicable time period. In other words, they simply did not get it in on time. So with the extension of the applicable time limit for EOM to issue a determination, it was 25 days, excluding the weekends and the legal public holidays. The request was received on December 22nd, 2023. Therefore, EOM was required to have responded by February 1st, 2024, which they did not. The third problem was DC FOIA does not provide for use of multiple extensions. That is pretty obvious. As you saw, there were several requests for extensions, of which the requester agreed to most of them. However, that was not the proper use of FOIA, of DC FOIA, because DC FOIA does not provide and has no provisions for multiple extensions beyond one. Another problem was a failure to provide a timely determination of the December 2nd, 2023 FOIA request. It became moot once EOM issued a determination, and this is the relevant case law involving that. We know that mootness occurs when there's no case or controversy in dispute, and in this case, that is the case because EOM had eventually provided the records as requested. So therefore, the petition to failure regarding a failure to provide a timely determination did become moot once those records had been delivered to the requester. So the conclusion of this particular matter is when the agency doesn't make a determination within the applicable timeframes, 1 DCMR 405.5 provides that the agency must notify the requester of four things. The reason for the delay, the date on which a determination may be expected, and the right to treat the delay as a denial and of the appeal rights provided by DC FOIA. In this case, EOM provided the requester with the reasons for the delay and the subsequent dates on which determination might be expected. However, EOM did not notify the requester of their appeal rights, which FOIA law requires that they do. Also, DC FOIA provides for the issuance of only one extension. Now, while FOIA law indicates that the agency may continue to process the request, the issuance of several successive notices of extension does not conform with district FOIA laws and regulations. So the director's recommendations in this particular matter is with all future FOIA requests, EOM should strictly adhere to the requirements of the relevant codes, of course, and that EOM should ensure that no more than one notice of extension is issued in accordance with provisions of that relevant law. And when a determination can't be made within the applicable time period, EOM must ensure that the requesters are informed of their rights to treat the delay as a denial and their appeal rights, as a denial and their appeal rights under DC FOIA. So now we'll move on to our second case. This was a FOIA appeals backlog case and involving the Mayor's Office of Legal Counsel. It addresses the backlog of administrative appeals under DC FOIA. So the request for an advisory opinion regarding the Mayor's Office of Legal Counsel's continuing delay in publishing its administrative appeals decisions under the District of Columbia Freedom of Information Act. The requester had specific questions, and they were whether a delayed publication of the opinions in the DC Register at a pace set by the agency and the Register by itself a proper implementation of the DC FOIA proactive publication requirement. They asked also whether the publication of DC FOIA appeal decisions by the MOC in the DC Register, affords searchability that meets the requirements of DC Official Code 2-534B. And is the Register an adequate substitute for the district's publication website publications? So before we go into this particular case, we have to go back a little, just as the advisory opinion does. And it references a previously issued advisory opinion, and you see the number there. And in that advisory opinion, because it was dealing with a very similar matter, you'll find that oftentimes, not only does the public get to reference all of our advisory opinion, we often reference our own past advisory opinion in rendering new advisory opinions. And in this particular advisory opinion, the director provided an overview of the DC FOIA administrative appeals process and described how the deadlines were suspended by legislation during the COVID pandemic. In addition, the director also analyzed Moak's docket relative to the information on the unavailability of appeals decisions from the public provided in the requester's request letter. The mayor's report stated that during that time that of the 519 appeals submitted to the MOC in fiscal year 2020 and 2021, 46% were overdue at the end of FY 2021. So half, better than half, almost half. So further background regarding the same previously issued advisory opinion. So at that time, there were no full text of any recent FOIA appeal decisions by the MOC available that were available online. And the director went on to say that it had appeared that the MOC had not affirmatively released any FOIA appeals decisions in the DC Register since November of 2019. Remember, this was a 2022 opinion. And DC FOIA and its regulations do not require that the MOC decisions appear in the register, but that the MOC must at least post them on its website. In that same opinion, the director reported that the MOC's director had cited 3 specific reasons for the appeals publication delays. One, the executive decision to stay MOC's processing of FOIA responses because of the pandemic. The lack of adequate resources, obviously insufficient workers, and getting responses from custodial agents in a timely manner. As I mentioned earlier, oftentimes when there are appeals or where there are questions about FOIA requests or things like that, usually investigations have to take place. Usually one agency has to talk to another agency. And so the director of the MOC at this time saying that, getting responses from other custodial agencies in a timely manner was one of the reasons for the delay. The director also opined that the delay in the MOC disposing of FOIA appeals is in part due to the brevity of the administrative review period under DC FOIA law. So in other words, the director of OOG herself kind of stepped in and said, well, the statutory deadline, quite frankly, is too short. 10 business days limit for final FOIA decisions in relation to its federal counterpart and to the corresponding laws in some of our neighboring jurisdictions like Maryland and Virginia. So the mayor recommended that the mayor seek a legislative remedy through the DC Council that properly addresses the inadequate processing times and perhaps adopt an unusual circumstance extension, just as it does, just like it's available for first level DC FOIA responses and the federal FOIA appeals. So going into the case. So in preparation for response to the requester's letter, I, at the time, contacted the MOC's FOIA officer, and I relayed the requester's specific concerns, and I sent an email regarding the requester's initial inquiry. There was information that they had gathered from the MOC's FOIA's office. The FOIA officer at the MOC informed me that they were working on a project to provide public access to all of the previously unreleased MOC appeals from 2020 to the present. And they were going to post them on the DC Register. So there was this whole ongoing project to get all of these backlogged appeals posted to the DC Register. He also informed me that the endeavor entailed a multi-step process, which I'll speak about a little bit later, and it would take some time to complete, but they did not give a a definitive date as to when it would be completed. He also explained that the decisions needed were prepped in a specific format prior to publication. At that time, 600 of 1,008 decisions had been prepped into the required format. It was explained to me that they obviously have to be in a particular format. If anyone has ever published anything on a DC register, you do know that there are formatting requirements. And apparently one of the things that they had to be concerned with over at the MOLC was that all of these documents would be prepped and formatted properly so that they would be accepted by the register. The MOLC apparently had also been in discussions with the register regarding a publication schedule and a timetable for posting, as opposed to overwhelming the register all at once with 1,000+ decisions. They were also working with the folks over at the DC Register to post and publish these backlog final orders, determinations in a manner that does not overwhelm the register. The MOLCs are also accounting for some of the delays in the preliminary administrative process. They said that there would possibly be some back and forth, there'd be some administrative issues. So that would also account for some of their anticipated delays. So one of the things we will look at now is the judicial review and the MOLC's administrative review process. So any person denied access to a public record may pursue judicial relief by filing complaint for injunction or declaration in Superior Court of DC, or may first seek administrative review by petitioning, that is sending an appeal to the mayor's designated agency. And in this case, it is the Mayor's Office of Legal Counsel, as it has been since 2015. An appeal to the mayor shall be in writing. This is under 1 DC MAR 412.3. It shall be in writing, and the appeal letter shall include Freedom of Information Act appeal or a FOIA appeal in the subject line of the letter, as well as marked on the outside of the envelope. It's also always hysterical to hear them talk about letters and envelopes. As you can imagine, the MOLC's website states that the MOLC accepts and actually prefers appeals sent by email at the FOIA.appeals@dc.gov. So, advise people to do emails if they can and not send letters. The requester should also forward a copy of the appeal to the Freedom of Information Officer or the agency head in the absence of the designated FOIA officer of the agency whose denial is the subject of the appeal. So not only should this go to the MOLC, it should also go to the FOIA officer or the designated person of the agency where the appeal, which is the subject of the appeal. 412.4 says an appeal to the mayor shall include, these are things that should be included in the appeal, a statement of the circumstances, reasons, or arguments in advance in support of disclosure, a copy of the original request, if any, a copy of any written denial issued under section 407.2, and a date, time, telephone number, email address, or mailing address for the requester. So section 412.5 deals with the processes. So the processes, the deadlines, and the responsibilities of the agency on which the appeal to the MOLC was filed. So we're not going to go through all of that because those are specific to the agency, and really we want to deal a little bit more with what we're discussing as far as the MOLC itself. So I'm going to skip all of that, but although you can certainly go to the advisory opinion and it is all there. But for purpose of this presentation, I'm going to skip that. It's not relevant to what we're trying to get through today. So in a discussion of this discussion section of the advisory opinion, MOLC's additional plans for timely publication of FOIA appeals decisions and implementation of its previous and recent plans. So the AO discussed the progress. since the MOLC's initial correspondence regarding its plans and progress. 3 months after the MOLC's initial letter to the OOG relaying its plans for publication, all of those 1,008 appeals had been prepared. They had been formatted for posting to the DC Register. The MOLC had also been working with the Register to publish opinions and was sending them over manageable batches, just as we discussed. The MOLC had also reported that the Register was posting decisions. Okay, not a sizable amount at that time, but progressing. This was the progress that had been relayed to me from the MOLC's FOIA officer 3 months after we had initially spoken, saying, hey, just to let you know, here's the progress, because our requester at that point, as you can imagine, was getting a bit impatient because they were not sure when progress would actually be made. And they wanted to get a better understanding of not just the process, but when there would actually be some finality to it, and there would be publications on the MOLC website. There are many other concerns, and we will get to those very shortly. So the director acknowledged that that while the MOLC had taken impressive steps to complete its plans for processing some of the appeals, its delay in doing so was still out of compliance with DC Official Code Section 2-536A3. I think one of the things that is always interesting is that when we are dealing with issues or appeals or complaints, requests, where one party is clearly out of compliance, but then they're making every effort to get in compliance, we're still obligated to let them know they're out of compliance. It's always helpful because we, again, our concern is much more with compliance rather than punishment, and we can't actually punish anyone with FOIA anyway. But we still always interested in helping agencies, or helping any entity, or helping our citizens to get information, gain information, so there can be a better understanding of what those folks who are tasked with running our government, what they're doing. So we acknowledge that progress was very impressive, but they were still out of compliance. And so, speaking of DC Official Code 536, that is our proactive disclosure requirements of the DC FOIA. That particular code requires, amongst other things, that the following categories of information are specifically made public information and don't require a written request for information. They should already be posted on your website or available for public review. That is correspondence and materials referred to by and with the public body relating to any regulatory, supervisory, or enforcement responsibilities of that public body, whereby the public body determines or states an opinion upon, or is asked to determine or state an opinion upon the rights of the district, the public, or any private party. Now, the director pointed out that it was actually DC Official Code Section 2.536A3 was more applicable to the concerns of the requester in this case, because that related to the publication of final opinions, which is what these MOLC appeals determinations are. They're regarded as final opinions, including concurring and dissenting opinions, as well as orders made in the adjudication of cases. So then the question arose about MOLC and DC Register and this independent publication arrangement that they made. You remember I was telling you that the MOLC FOIA officer was informing me about arrangements that they were making directly with the DC Register in order to implement a timeline, a time frame, how many badges they would take at a certain amount of time. So they were in themselves, trying to make this work. They were corresponding open with each other. And Obviously, that seems to be a good thing because you're trying to make some type of arrangements. But that was one of the questions that the requester was concerned about. And the question was, is there any provision within DC Official Code Section 2-536 which grants exceptions or exemptions to proactively publishing the required opinion? Well, and the answer to that is no, there's not. And that's a real word in many Southern places. You can ask attorney advisor Brandon Lewis and even the director. We know a little bit about the South, so that's a real word. No, there is not. So the searchability. There was also the question about the searchability of the DC Register for MOLC's FOIA appeals decisions. DC Official Code Section 2-536B. Each public body must make available to the public all public records created on or after November 1st, 2001. The statute mandates that those records be made available on the internet, or if a website has not been established by the public body by other electronic means. So as this relates to the MOLC, the searchability aspect, if the appeal decisions are locatable on the internet, then the MOLC's website or some other electronic means, and the MOLC had satisfied the requirements of the subsection. However, where a more readily accessible means is available to disclose the information publicly on the internet, as in the MOLC's website or any other electronic means, then the MOLC should utilize that means. In other words, if they had available some other means, electronic means of this information being able to be located other than a DC register, then that is what they should use. The MOLC had been publishing its appeals on the DC register. And of course, that begged the question whether the DC register is an adequate substitute for the district's publication website publications. That was the question that was asked by the requester in subsequent correspondence to us. And of course, that is a question that we had to investigate. DC Official Code Section 2-536 does not address the degree of search that's acceptable to locate information that must be made available to the public under the said section. The statute requires that appeal decisions be made public without a written request. So therefore, what it's saying is the degree of difficulty with which records are searchable, it doesn't necessarily equate to that record being unavailable. So just because it's not, you can't find it that easily, does not automatically mean that it's not available. Although public availability, when you talk about public availability, that does suggest that information is more easily accessible than not. So while there's nothing that says, it has to be easy to be considered available, it also says that if it's supposed to be publicly available, then it really should be easy to get to. So in this case, the MOLC had a backlog in the disclosure of its FOIA appeals decisions while utilizing the DC register as a means of disclosure. And that was obviously problematic and probably not the best and the most efficient mechanism by making their records searchable or easily findable. So the director had recommendations and conclusions for this particular case. One was that the MOLC hire contractors to help specifically with processing the FOIA appeals decisions for public disclosure. That the MOLC explore additional means of disclosing its FOIA appeals decisions on the internet. If such is not feasible, then via the MOLC's website. That the district reform the FOIA appeals process to permit the mayor to reasonably dispose of FOIA appeals. In other words, maybe DC Counsel should consider amending the DC FOIA to permit the mayor's Office of Legal Counsel 20 business days or more to complete the DC FOIA appeals. As we said, some of our neighboring jurisdictions have a longer time period. Director also recommended and concluded that the Office of Open Government should also officially serve as the DC FOIA Ombudsman, just as the federal government Office of Government Information Services does. OOG would provide confidential dispute resolution, allowing requesters and the public bodies to engage in candid and fruitful discussions of their issues and concerns. And in this process, OG would be a neutral referee to resolve the conflicts, and it would continue its efforts to ensure fairness in DC FOIA processing by serving as an impartial ombudsman. I always thought this was a brilliant recommendation by the director, simply because having worked at another agency where all of the administrative law judges and all of the attorneys are trained and certified mediators, it was a very vibrant mediation program, and that helped to curtail tremendously the number of cases that the judges had to hear. Therefore, they were able to write more final orders because they didn't have as many cases that they had to hear. The clerk's office was able to process many more cases in a timely manner and an efficient manner because they were not overwhelmed by the number of cases that needed to be litigated, simply because there was a mediation program available that helped to reduce the caseload. So I thought this was a great idea. So if anybody knows anybody, up top, and they want to hook us up with this type of designation, then, hit me up after the presentation. So our last and final case, again, is one that we've discussed a while back, but I thought it bared discussing again. And the reason why is because a lot of our FOIA officers, people who have to undertake the role of having to process these FOIA requests, sometimes you guys maybe take on a kind of a superhero type of personality, and understanding that you do have limitations, and some of those limitations include technology. Sometimes, the nature of the FOIA request itself can sometimes be a bit overwhelming, and you do the best you can, but there are provisions within the FOIA law itself that kind of got you back if things get a little rough, and then they're out of your control. So the request was for us to evaluate the DMPED's denial of a request by an individual for public records under the Freedom of Information Act. So the question was, may an agency justifiably deny a DC FOIA request when the agency's information technology system would be disrupted or disabled by the process of reviewing emails that the agency received from the Office of the Chief Technology Officer. So the requester's original request to this particular agency, and this is it verbatim. I don't put everything in there, but you'll see where I'm heading with it. They wanted one copy of every document, email, audio recording to or from the director or acting director of DMPED, and one copy of every document, email, or audio recording to or from any staff member of DMPED between January 1st, 2022 and December 29th, 2023, and containing any of the following: 562 Connecticut, all that. Now, you see all those dots I have there? If you go to this opinion, I think that's about a paragraph or two beyond that. So, and not just those that follow those words, but also any attachments, any emails, any type of things in the main body of the email. So you get the point. This was a very specific and very long and voluminous type of request. And so there you have it. So discussion. DC FOIA provides a right of access to public records and requires a reasonable search, but it limits an electronic search for records if it would significantly interfere with the operations of a public body's electronic system. And that is the relevant code regarding that matter. In other words, DC provides for the right for you to have the public records. But there's also the issue of significant interference, where it could literally, if fulfilling this record is going to significantly going to crash your system or something like that, then there are provisions within the FOIA law that allow you some leeway. So other facts. So DMPAT conducted a search as defined by Section 2-532A2 when DMPAT's FOIA officer attempted to review the files provided by Octo. DC FOIA requires a public body to make reasonable efforts to search for records and to attest that a search for the document was reasonably calculated to discovery response documents. And that's case law, Wisberg versus Department of Justice. So in other words, there is a requirement to make a reasonable effort and to attest that a search for the document was reasonably calculated to discover the documents. So not only are you making the effort, but you're also required to assume that this particular effort will result in the requested records. Agencies are required to conduct a thorough and a good faith search of records, and that's also case law Golan versus the CIA. In other words, you're doing your best. The request comes in, it's very specific, but you're doing your best as the FOIA officer or the point of contact for these requests to make sure that you fulfill these requests. Significant interference. Now, significant interference occurred in this case when DMPAD's IT failed when the FOIA officer attempted to use an application to review the files provided by Octo. DMPAD's FOIA officer attempted to narrow the scope of the request to facilitate production, but the requester refused. So all of those search terms that we were looking at before that you'll see more clearly if you go to the actual advisory opinion on our website, the requester was like, no, I want it done just like this. But the FOIA officer then attempted to fulfill the request as written, thereby causing an actual disruption of the agency's systems. So a public body is not required to undertake a reasonable search of the electronic records if the search would significantly interfere with the public body's automatic information system. However, it is the public body's burden to prove that such an interference exists. So DMPAD should have conducted the search that would yield the results of the request, even though the requester insists on specific terms. In other words, the director said that, hey, you do have an obligation to fulfill this search, but you use your own judgment, FOIA officers. I mean, to the extent that, you're going to have requesters who are going to, they want. I don't think many of them are being malicious. I think, in fact, they're just trying to cover their bases. They're trying to be as specific as possible because they want to make sure they get as much of the responsive record as they need. And so they may put in a whole lot of stuff and expect you to put in a whole lot of stuff in order to retrieve these records electronically, not understanding that all of that stuff could very well overwhelm a system. So as FOIA officers, you have to be able to use your own judgment and be able to make a request of these systems that was reasonably calculated to get those records, but that would yield the results, but without overwhelming your system. I believe that someone have a hand. I don't know if someone's hand is raised there. I think Mr. Watson. I think.
Yes. Hi.
Hi.
I had a clarifying question on this advice because this actually was my FOIA request from nearly 2 years ago.
Look at you.
So thank you for reinforcing that we were right in denying this request. But if we were justified in denying it, how do we square that with the obligation to still process it using our own judgment? And I'll have a follow-up probably after that.
Well, I mean, you process, well, using your own judgment is you that simply means, it's not, using your own judgment doesn't mean you just ignore, what the requester has put. But you do it to the extent that you can fulfill the request, but without overwhelming your system. I don't know if that sounds circular, but I think you can still fulfill the request, but without doing so in a way that can overwhelm your system and cause, again, this significant interference that we're trying to avoid.
Yeah, it makes a little sense, but one of the problems that we've had requesters who have done the flip side of this, of to avoid hitting this problem of, so in this case the requester asked for 5 years worth of emails with all of those keywords for every staff member. What I've seen instead from some requesters moving forward is much smaller batches, in a way that we still think the request might be overbroad, but they've broken it up so small that we can't necessarily accuse them of doing so. For example, they'll say, okay, well, I want all the emails from this one person from this 2-week period. Then we fulfill that request, and then a little bit later they come back and do the same thing and the same thing and the same thing. As much as I hate that, I do prefer it to the idea that I should have tried to break this request down, because there was no way, one, given what the requester was looking for, that I could have done it in any timely manner, or two, done it without crashing the system. It's at least better when a requester submits multiple possible to fulfill requests, because otherwise I'm left with choosing to deny or choosing to, like we saw with the first case that we looked at, constructively deny when I just can't get it done within the legal time frame.
Right. So are you saying then that that you would suggest to requesters that have, maybe a voluminous request or a request that would otherwise be overwhelming to you, just send it to us in pieces? Is that what you would suggest to requesters?
It's not necessarily what I would actively advise them of, since it's usually not my business to advise them on how to get better FOIA requests.
Sure.
But I do use, in the case of this requester that we're reviewing, I did originally call them and talk about why I wasn't going to be able to process it as written, how I might be able to process it a little better. And they were almost amenable until they got an attorney involved.
Oh, God.
Problem of the profession.
Wow. Yes. I'm sorry to hear that happen, but that is again, we always talk about our burdens of being DC government employees and the burdens that we must suffer sometimes, and that's one of those things. But we certainly do the best that we can. And obviously, if you run any issues or have any questions about how to handle a particular situation, we're always here to help out as best we can.
Which I appreciate. So I guess the circle back here is so when I submitted the request for advice from Bega for this, it was because we wanted to have on record an opinion that we've tried our best to resolve this. But ultimately we decided that we should deny this request. Is Bega's position that if I got this same request today, I shouldn't deny it, but I should instead try and find a way to do it that doesn't crash the system?
Well, that would be so fact specific that I would wait till that happened.
Sure, I respect that.
Probably won't render any verbal advisory opinion right now, especially when my boss is watching. So we'll wait on that. But if that happens, feel free to let us know, and we'll certainly analyze it for you.
I appreciate that. Thank you.
Absolutely. We appreciate you too. Absolutely. So continuing. So DEMPED should have conducted the search that would yield the result of the request, even though the requester insisted on specific terms. In Pinson, the court made clear that an agency has the responsibility to conduct a search that is most likely to yield the records requested. 2 cases where agencies faced with a burdensome search resolved the issue by conducting a search for a record in a manner deemed most appropriate. And that is when an agency has conducted numerous searches, and when an agency has conducted a broader search that produced the records sought. So DMPED was not bound to use the specific terms of the requester, just as we were talking, in order to execute a reasonable search. It should have concluded the search that would have most likely yielded the results the requester was seeking. So in concluding that case, the director concluded that concluded that in this instance, DMPED correctly denied the request as unreasonable because the review process actually disrupted its information technology system. When faced with a demand to conduct a specific electronic search, the agency is not bound by the specifics of that requester. The agency's FOIA officers should instead conduct an electronic search that will yield the records the requester is seeking that will not compromise its systems. Okay, well, that concluded that particular case. This is our contact information, which we will certainly provide for you again. And here is our contact information for all of our individuals. Again, our director is Neal Allen. I'm Louis Neal. I'm a chief counsel. Our attorney, Joan Lelma, is one of our attorney advisors, as is Anthony J. Skirbo and Brandon Lewis. And Kimberly Brown is our paralegal specialist. And Kevin Brown is our IT specialist. So I would like to thank each and every one of you for attending my presentation today. And if you have any questions, you can ask now. Or if there are any questions you would like to email at some point, we'd be happy to answer those questions for you. I'm not sure if anything was sent in the chat, if there were any questions answered in the chat or not, but please feel free to ask us any questions or make any comments or any observations that you think would be helpful to us. We'd be appreciative of it. Thank you all very much. I'll just hang around for a few more minutes. So if anyone has any questions while you're hanging around, otherwise I will watch people go ahead and conclude and go back to their regularly scheduled program of work. But I'll be here just for a couple of more minutes before I close out.